Welcome to the Academy of Law's second 2016 lecture. This lecture has been approved for 1 unit of CLDP credit by the Legal Affairs Department. So be sure to pick up your LAD registration card on the way out. And we greatly appreciate it if you completed your questionnaires at the end of the program. Thank you very much. I have the distinct honor of introducing our esteemed guest speaker. Sir Julian Martin Flaux, styled the Honorable Mr. Justice Flaux, is a British High Court judge. He was educated at the King's School, Worcester, and Worcester College, Oxford. Sir Julian Flaux was called to the bar in 1978 and practiced at the commercial bar from 1979 to 2007, specializing in disputes involving insurance and reinsurance, shipping, international trade, and professional negligence. He was appointed a QC in 1994, an assistant recorder of the Crown Court in 1997, a recorder in 2000, and a deputy High Court judge in 2002. He was appointed a High Court judge in May 2007. He was presiding judge at the Midland Circuit from 2010 to 2013. He was judge in charge of the Commercial Court from July 2014 to December 2015. He was appointed as a member of SEAC in March 2013. The appointment as chairman of SEAC, POAC, and PAAC is for 3 years from the 1st of January 2016 to 31st December 2018. Sir Julian will discuss the topic challenges facing the commercial court and proposed solutions. So with that, let me turn it over to the Honorable Mr. Justice Flaux. Thank you.
Thank you very much for inviting me to come and speak to you at the DIFC today in what I hope is a further manifestation of the friendship and cooperation between the Commercial Court in London and the DIFC courts. I've been asked to speak, as David said, about the problems facing the Commercial Court and proposed solutions. But in tackling the topic, I suspect that the problems I've identified are ones which, in a very real sense, trouble all common law jurisdictions which seek to resolve commercial disputes of one kind or another. Without a doubt, the biggest problem and challenge which is faced by the Commercial Court in London is disclosure, and particularly electronic disclosure, and how to manage and limit it. From a judge's perspective, the volume of disclosure in a major commercial case seems to be in inverse proportion to its utility at the end of the day. And far too often, all or most of the disclosure finds its way into the trial bundles which proliferate, but the experience of most judges is that only a very small proportion of the documents in the trial bundles are actually referred to or put to the witnesses at the trial, and time and again the documents on which the result of the case actually turns are an even smaller proportion of that small proportion. So how do we get into this mess, and how do we get out of it? There's no doubt that in the last 25 years or so, in which email has become the universal means of communication, the amount of material available which may require to be disclosed has expanded out of all proportion. Part of the problem about electronic disclosure, I think, is that the methods of retrieval which have to be employed, which will often require using third-party consultants to carry out the disclosure exercise. What happens far too often is that even after the volume of material has been reduced by the use of appropriate search terms and deduplication, the amount of material left is so great that in a sense it's easier and probably cheaper to disclose all of it rather than have experienced lawyers go through the electronic files identifying what is really relevant and disclosable. What transpires is not only a time-consuming and expensive exercise in giving disclosure, but an equally time-consuming and expensive exercise in considering the other side's disclosure in any major case. In one recent judgment, where a trial of a major piece of litigation had to be adjourned because the disclosure process had got out of control, one of my Chancery colleagues criticised what he said appeared to be an unfocused disclosure process which has fanned out exponentially and extravagantly without sufficient control and direction. The commitment of increasing resource to the identification of documents, leaving a diminished resource for their assimilation, without properly taking stock as to whether the process had overtaken the purpose. Well, that was an extreme case, no doubt meriting the criticism in that case. But any judge with experience of case management or trying major commercial litigation would find an echo there of his or her own experience. We as lawyers have to recognise that whilst the process of disclosure may make money for all the lawyers, the clients are not happy. Recently, a group of the General Counsel of major UK companies approached the senior judiciary in London to express their concern about the financial and human burdens of the disclosure process and made a request that the judges try to find solutions to the problem. So what solutions can be found? One of the great selling points of the commercial court in London has always been active case management and the fact that interlocutory hearings are conducted by the judges and not by masters. One of the things that I've tried to do when I was judge in charge of the commercial court was to encourage parties in appropriate cases to apply for a designated judge to be appointed so that one judge would conduct all case management hearings and then the trial. But resources are such in London that it's not possible to do that in every case. But in any major case where there are likely to be multiple case management hearings and interlocutory disputes about matters such as disclosure and expert evidence, it seems to me it's to be encouraged to apply for a designated judge. And if there is a designated judge or docketed judge as described in the United States, he or she will be able to master the issues in dispute in a way which isn't always possible if you are dealing with a busy applications list on a Friday, following 4 days of trial, Monday to Thursday. The use of designated judges is also a hallmark of the new financial list, which I'm sure you've all heard about, a new cooperative venture between the Commercial Court and the Chancery Division, designed to ensure that complex financial disputes are managed and tried by judges with the right type of commercial experience and knowledge of how the City of London and other financial institutions work. And the ethos is essentially the same as led to the foundation of the Commercial Court some 120 years ago. What Commercial Court judges are trying to do by way of active case management in relation to disclosure, whether as designated judges or generally, is to wean the parties off the default position under the civil procedure rules of standard disclosure. For example, by looking critically at the issues in the case and asking the lawyers in relation to particular issues whether more limited disclosure would be appropriate. For example, that procedure commonly used in international arbitration of a party disclosing the documents it relies upon in relation to a particular issue, and the other party then being able to call for additional disclosure on that issue if it can really demonstrate the relevance of the particular documents. That's a system of disclosure which has its critics as well, and I'd be interested later on when we have a Q&A to see what people have to say about that, because I suspect you've got more experience of that here than we have certainly in a court context in London. Another case management tool which certainly I've threatened on occasions is to say to a party who is pressing for disclosure from the other side, which will be expensive and time consuming and the relevance of which appears to be debatable, is to say, well, if you want that disclosure, then at least in the first instance you will pay for it. And surprisingly enough, quite often those applications are not pursued. In relation to some issues in a case, particularly in relation to construction of contracts, the judges may say, well, there should be no disclosure at all, or only very limited disclosure. And let me give you a concrete example of that. Anyone who's practiced commercial law in the last 15 years or so will be aware that one of the, no doubt, unintended consequences of Lord Hoffman's judgment in the Investors' Compensation Scheme case is the use of so-called factual matrix or background to poison the judge's mind as to how he should construe the contract. Far too often, that's led to disclosure and the attempt to use at trial documents which demonstrate no more than the subjective intentions of the parties and therefore strictly inadmissible in evidence. Parties often aren't deterred by that. They will also seek to call witnesses who were involved in the negotiation of the contract, or sometimes even witnesses who weren't involved in the negotiation of the contract, to give evidence as to what they think the contract means. In order to stem that particular tide, we in the Commercial Court now require parties in factual matrix cases to prepare a joint schedule in any such case, setting out which aspects of the background are agreed or a common ground between the parties and which are in dispute and why. And that enables the judge to limit disclosure, or for that matter to limit witness evidence, to what is strictly in dispute and relevant and admissible at an interlocutory stage by way of an order, a case management hearing. So you don't then find a situation where at trial you've got a whole load of documents and witness evidence which is strictly speaking neither relevant nor admissible. And in some cases, obviously, where the background is pretty much common ground, you can dispense with disclosure or witness evidence altogether on that particular issue. Of course, one of the consequences of extensive disclosure, apart from cost, is delay in the case being ready for trial. So one of the solutions to the two particular problems of disclosure, which we've just begun to use in the Commercial Court and other courts in the Rolls Building in London, is the shorter and more flexible trial scheme. The shorter trial scheme is for all cases of 4 days or less, where the parties agree to adopt the scheme. So it's an opt-in scheme, although judges are going to encourage parties to opt in appropriate cases. And the features of the scheme are short pleadings, no more than 20 pages, standard disclosure dispensed with, and only disclosure of documents relied upon or specifically requested by the other party. All factual and expert evidence in short written statements or reports, with oral evidence being given only if strictly necessary. And the aspiration is 10 months from issue of proceedings to trial, 8 months from case management conference to trial, with the case being managed and tried by a designated judge, and judgment to be delivered within 6 weeks of the conclusion of the trial. Alongside that shorter trial scheme is the flexible trial scheme, which allows the parties by agreement to adopt procedures suited to their own case, and that's designed to limit disclosure and confine oral evidence at trial to the minimum necessary to fairly decide the dispute. And the idea, again, there is to reduce costs, trial lengths, and waiting time to get to trial. So far, those schemes are very much in their infancy, and it remains to be seen to what extent they are a success, and obviously to an extent they are only dealing with shorter cases, although the flexible trial scheme, there's no reason why that shouldn't be adopted in a larger, more complex piece of litigation. Of course, nothing's new. When the Commercial Court was set up in 1895, it was not just to avoid commercial disputes being decided by judges who thought that a charter party was some form of society ball, but to introduce streamlined procedures. And I had the volume of law, or a series of law reports called the Commercial Cases, which was started in 1895, and I had in the front of my copy of Commercial Cases a manuscript note of a summons for directions, which was, those of you who are over 40 will remember, is what case management conferences used to be called. And the hearing was before Mr. Justice Sterling at Manchester in 1898. The judge said he dispensed with pleadings altogether and said that discovery, as disclosure was called, should be reduced to the documents that the parties relied upon, and the judge would know if one of them was trying to conceal something. And I've often wondered how he would have known if somebody was trying to conceal something, but it doesn't reveal that. He then ordered trial before himself at the Liverpool Assizes 2 weeks later. Estimate 1 day. I suspect if I ordered anything as streamlined as that today, the lawyers would all have heart failure. Another recent and more radical development, for us at least, is the long-awaited advent of electronic filing, in which I think your courts are a long way ahead of us. After a disastrous failure of a previous package, the latest system, CE file, has been devised by Thomson Reuters, recently introduced in all the courts in the Rolls building, and it will, we hope, evolve in time to all cases being issued online and all documents filed with the court electronically, with the aim of having in due course a paperless case management system. And the aspiration is to increase efficiency, reduce delays and cut expenditure. The introduction of electronic filing and case management systems dovetails into the other aspect of modern technology, which is having a considerable impact on cases conducted in the Rolls Building courts in London, which is paperless trials. Trials where all the trial bundles are placed onto or uploaded onto a document management system, which enables the judge, counsel and solicitors to view them anywhere in the world, including in the office and at home, or even actually when you are on holiday in Dubai and Oman. From an entirely personal perspective, this will in due course eliminate the repetitive strain injury of lifting off the carousel bundle after bundle of documents which weigh in as heavy as a healthy baby. Joking apart, I'm convinced that this is the way forward for the future. It is still a very expensive system, but one suspects ultimately no more expensive than all the paper and lever arch files. One thing, however, that does seem clear is that paperless trials will not lead to an alleviation of the burden of disclosure. Another problem facing the commercial court, and I suspect many other courts, concerns witness evidence, in particular how it's presented and its function. We are now a very long time away from when all the evidence was given orally at trial. In commercial cases other than fraud cases and some cases where there's a real conflict of oral evidence, for example, about what was said at a meeting, it's very rare for evidence in chief to be given orally. Instead, for many years now, evidence in chief is given in writing, in carefully fashioned witness statements, and with no disrespect to the solicitors here, these are often drafted by the solicitors in language which sometimes does not reflect the witness's own way of speaking, and which is not always entirely aligned with the evidence which the witness actually can give. And what that leads to far too often is cross-examination, not about the witness's actual evidence, but about the words used in the witness statement, or questions about whether the evidence was written for the witness. The witness, of course, always says that he wrote his own statement, even though everybody, including the judge, knows that in fact it was written by the solicitors, having had interviews with the witness. Far too often, in my experience, that leads to a perfectly respectable and straightforward witness being made to appear tricky when he or she cannot justify what has been written in the witness statement. And the remedy for that problem, as I always say to people when I give talks for example, to people who are from particular professions who may be called upon to give evidence, and that includes lawyers, is if you ever have to do that, make sure that the witness statement you sign is expressed in language you would use and reflects precisely the evidence that you can give. Nobody's going to criticise you if you say, that doesn't actually reflect what I really recollect, or I would not put it that way, I will put it this way. A related aspect of the overall problem with witness evidence is cross-examination. It's fair to say that whilst there are some brilliant exceptions, as a general rule, commercial barristers lack the incisive cross-examination skills of the criminal bar. Far too often, cross-examination consists of a trawl through the documents, putting every single document of any relevance which a witness produced, or which was sent to him or her, or alternatively, expressing outraged surprise when the witness cannot remember what he or she was doing on the 7th of February 4 years ago. Of course, I wouldn't be able to remember in 4 years' time what I was doing on the 7th of February 2016, because I would recall that I was speaking to you. But far too often, as we all know, memory is a strange thing. Sometimes people do remember things that happened because of the significance of what happened afterwards, and that's obviously something that, for example, people who've been involved in accidents or disasters of one kind or another will remember. But quite often, the parties are simply engaged in their day-to-day work. The dispute, whatever the dispute is, arises later, and there's absolutely no reason why you would remember something that happened 3 years ago, unless you had some cause to remember it at the time, so that it would fix itself in your mind. So questions about why can't you remember this or remember that always seem to me slightly wider than mark. Commercial court judges in London now quite often impose time limits on cross-examination, either in relation to a particular witness or more frequently in relation to the number of days that opposing counsel will have to cross-examine a party's witnesses. So you say, if you've got 7 witnesses, you can have 5 days or whatever it is to cross-examine them. And if you don't, how you use that time is a matter of you. At the end of the 5 days, the bar comes down and that's your lot. Of course, cross-examination remains of considerable importance, not only where issues of credibility genuinely arise, but also where there are issues of recollection. And reading the witness statement of a witness may not give you any clue as to whether the witness really remembers what happened, say, 3 or 4 years ago, as I say. Of course, there are many cases where the contemporaneous documentation is a better guide to what happened than necessarily flawed recollection of witnesses. But it is surprising how many cases, even the commercial courts, still turn upon the judge's evaluation of the witness in the witness box. The other problem which I wanted to touch on, which faces us, is that of expert evidence. And like disclosure, that's often an expensive process. However, one of the advantages of having case management by judges, and in the more complex cases by a designated judge who's going to be the trial judge, is the ability to focus the parties' attention on whether expert evidence is really necessary, and if so, on precisely which issues. It's important to find ways of limiting expert evidence, particularly certain categories of expert. I hope there aren't any forensic accountants in the room. They are the worst offenders in terms of straying beyond their area of expertise and telling the court what the answer to the case is, which they don't seem to appreciate is the job of the judge and not of the forensic accountant. And I think I can tell this story because I know that the Lord Chief Justice has recently been out here to speak to you. I remember when I was at the commercial bar doing a case management hearing on a Friday morning in front of Mr. Justice Thomas, as he then was in the commercial court, where my opponent applied for permission to call expert evidence of a forensic accountant. To be met by the answer from the judge, I'm not having a forensic accountant giving evidence in my court. A view that I sometimes sympathise with. In terms of how one can usefully limit expert evidence, the concept of the single joint expert introduced by the Wolf reforms in 1998 is not really suitable for complex commercial disputes and hasn't really been ordered very often. One of the reforms to civil procedure introduced as part of the so-called Jackson reforms is the concept of hot tubbing, which I think originated in Australia, where in effect both experts give evidence or express their opinions at the same time. This is not really caught on, at least in commercial litigation, and speaking for myself, I have some doubt as to whether there is much to be gained by two forensic accountants or two foreign law experts getting in a hot tub together, at least for professional purposes. My limited experience of the process is that it tends to descend to a free-for-all unless the judge is very careful and strict. And I'm simply not convinced that it's the best way of getting to what is at the heart of what is in dispute between experts, particularly in a specialist field such as, for example, naval architecture. It's almost impossible to conceive of two naval architects giving evidence at the same time. What the poor judge would make of it, I just do not know. But what we find in the commercial court works much better is not only insisting on experts meeting before trial with a joint memorandum setting out what is in issue and what is not in issue, but also ordering the experts in an appropriate case to continue to meet, to endeavour to agree, even during the course of the trial. Particularly in a long case, as the factual evidence unfolds, so the expert issues often come into sharper relief. And if the experts continue to try to agree what they really can, that means that the matters in dispute between them can be narrowed, and cross-examination then only needs to deal with those matters and not a whole host of extraneous matters or matters which aren't really in dispute. Of course, it won't stop the forensic accounting expert from waxing lyrical on issues of fact and law, but it does limit the scope for doing so. One technique that has been employed in the Technology and Construction Court in London, but which, as far as I'm aware, the Commercial Court hasn't adopted yet, but seems to me to be worthy at least of consideration, is to order the experts to meet in relation to a pre-prepared list of expert issues before they produce a report. So the very first expert stage, as it were, is a meeting between the experts to agree what can be agreed or disagree, and then they write their reports. So the reports are only dealing with the matters which are actually in dispute between them. And that does seem to me to be something that could usefully be considered in the commercial court as well. Well, I hope that my run through the principal problems which the commercial court in London faces doesn't give an impression of doom and gloom. Overall, I remain very upbeat about the way commercial litigation is conducted. Other than in very rare cases, there is cooperation between the court and the lawyers, and cases are fought hard, but usually in a courteous and civilised way, as I'm sure they are here as well. Long may it last. I hope never to witness in my court what I saw in San Diego 25 years ago when I went to give expert evidence on English insurance law in a federal court where the judge trying the case had been a judge since the year I was born. And the attorneys were at each other's throats, and American colleagues will apologise my attempt at an American accent. But the judge said, "Gentlemen, I will not have a war in my court. If you want to have a fight, go outside and punch each other, but don't do it in here." Thank you very much indeed.